rule?
This has actually been a topic that's been written and published about. So it is possible for someone to give testimony about a matter without interviewing someone. And there's certain sort of ways that it should be framed. So, for example, when Dr. Spiegel was testifying about the report that Mr. Depp was unable to recall these 3 objects, what he could have done is said that I have not personally examined Mr. Depp, so I can't speculate about his cognitive state or ability to function cognitively. However, it is possible that someone who's not able to recall 3 objects could have issues related to substance use, which was what his opinion was. However, what he should have done in expressing his opinion is then have followed up to say that in order to really establish whether these were relevant and significant cognitive deficits, Mr. Depp should have had psychological testing to establish the nature of these deficits. And he should also have added that there are other potential explanations for these findings. So, for example, it's possible that Mr. Depp...
Objection, Your Honor. He's now going past the designation.
I think he's just opining as to, or is responding to Dr. Spiegel's testimony yesterday.
No, he's opining as to what Dr. Spiegel could have said, but it's past the, whether he, about the
All right, if we can move on.
Okay. Who's qualified to give an opinion about cognitive deficits and processing speed?
It would have to be someone who could conduct the type of neuropsychological testing that I was mentioning. You can't establish the presence of cognitive deficits without a battery of tests.
Objection. Again, this is beyond the cold water rule.
Overruled.
You can't establish cognitive deficits without appropriate neuropsychological testing. And that can only be done by a psychologist or neuropsychologist. So a psychiatrist like Dr. Spiegel would be giving an opinion outside of his area of expertise if he gave an opinion about cognitive deficits that required psychological testing to be further evaluated.
Dr. Spiegel yesterday testified about the practice of forensic psychiatry. Do you recall that testimony?
Yes, I do.
What is forensic psychiatry?
Forensic psychiatry is a specialty of psychiatry that relates to matters on the intersection between psychiatry and the law. So, for example, what we're doing today is forensic psychiatry, where a psychiatrist comes into court and gives an opinion about a matter to help the court may come to an opinion.
Are there professional standards that govern the practice of forensic psychiatry?
Yes, there are.
And what organizations have issued those standards?
One of the primary organizations that has issued guidelines about the practice of forensic psychiatry is called the American Academy of Psychiatry and the Law. This is an organization that represents forensic psychiatrists. And it has published guidelines about what constitutes an ethical and sound practice of doing a forensic assessment and providing a psychiatric opinion. So this guideline, I think was published in 2015, actually contains many elements that are consistent with the Goldwater Rule. So, for example, it states that for a forensic assessment to be done, there has to be informed consent, and there should be a very thorough, comprehensive evaluation that would include reviewing past records, past psychiatric history. It would include doing what's called a mental status examination, which is a careful evaluation of someone's mood, cognition, things of that nature. And the guidelines do state that it is reasonable or permitted to provide an opinion without an evaluation, but if you're going to do that, there's some things that you have to really make clear in your opinion when you express that opinion. And the first is that you have to acknowledge the limitations of your opinion and not, like Dr. Spiegel, say that his opinion was held with a degree of medical certainty. you have to explain what's missing, what data you did not have that you were not able to rely upon in coming to that opinion. You also have to talk about what additional information you would need to come to that opinion. And even though these guidelines say it's permissible to do this, the text is still, I think, not fully in support of psychiatrists doing this. So their statements are that opinions rendered without a proper database, which is what we as psychiatrists rely upon to make diagnoses and give opinions, professional opinions, is questionable and not generally recommended.
Did you form an opinion about Dr. Spiegel's testimony with respect to these practice guidelines?
Yes, I did.
And what is your opinion?
Well, my opinion is that he did not follow those guidelines. So, for example, he did not have consent. He did not do even a basic evaluation of Mr. Depp. When he gave his opinions, as I just mentioned, he said they were opinions that he had to a degree of medical certainty, and he did not make any statements about what other additional information he would have wanted to make that opinion. So, for example, when asked about should neuropsychological testing be performed, he said most patients don't have access to that, which is actually not at all true. I mean, every medical school has neuropsychologists that can do testing. So I think that was an unfortunate statement. So I think those are the primary ways in which the Goldwater rule was violated, and the practice guidelines were not adhered to.
Dr. Shah, yesterday Dr. Spiegel was talking about correlation and causation. What is the difference between correlation and causation?
Objections. It's not in his designation.
It is. We can approach and I can show you.
Okay.
All right.
Go ahead, Dr. Shah.
Yes, so the difference between a correlation and causation, correlation is a statistical analysis of a relationship between two different factors. So in Dr. Spiegel's testimony, he talked about, there being a correlation between opinions he had about Mr. Depp, his narcissistic personality traits, his substance abuse, things of that nature. So a correlation doesn't say anything about whether or not these factors caused that, the behavior he was discussing. Perhaps one of the easiest ways I could describe this difference between correlation and causation is if we look at the issue of measles, if you'll bear with me. So there's a correlation between being young and catching measles. Now we know that measles is not caused by being young. Measles is caused by a virus. But young children have not been exposed to the virus. They don't have the immunity, so they have a higher rate of measles. So the difference statistically is, the difference is between causation and correlation is illustrated by that example. So another way I might put this is if we had 100 people in a room, just bringing it back to the issue of IPV that Dr. Spiegel was testifying about. Let's say we had 70 people who had all the risk factors for IPV and 30 people who had no risk factors for IPV. So what can we say about those 70 people? We can't say that any single one of those people has perpetrated IPV, even though they may have all the risk factors. And if we look at the 30 people who have no risk factors, we also can't say whether or not they have perpetrated IPV. So the actual presence of risk factors for IPV that Dr. Spiegel was talking about, they say absolutely nothing about what happened in this case.
Thank you, Dr. Shaw. Nothing further.
All right, cross-examination.
Good afternoon, Dr. Shaw.
Good afternoon.
You're not offering any opinion as to Mr. Depp's psychology, correct?
That's correct.
And you testified a lot about the Goldwater rule. You know of no case where an expert has been excluded from testifying based on the Goldwater rule, correct?
I don't know about the whole universe of cases. It's possible, but I don't know personally about one.
And you, before this case, you've never offered an opinion on the Goldwater rule before, correct?
That's correct.
And you've never written an article on the Goldwater rule, correct?
I have not.
And you've never given a presentation on the Goldwater rule, correct?
I have not.
And you've never been on any committees regarding the Goldwater rule, correct?
I have not.
Okay. And you agree that you've testified that there are exceptions to the Goldwater rule about having to interview the subject, right?
Yes.
And you understand that Dr. Spiegel requested to meet with Mr. Depp twice, but Mr. Depp declined, correct?
I'm aware of that.
And Dr. Spiegel stated in his designation and at trial yesterday that he did not meet with Mr. Depp, right?
Yes.
Okay. Can we put up Defendant's Exhibit 1904? Dr. Shaw, have you seen the opinions of the Ethics Committee on the Principles of Medical Ethics?
Yes.
Okay. And if you could turn to 79 of the PDF, and it's actually, thank you. You see where it's highlighted here?
Yes.
And it says, psychiatrists have also argued that the Goldwater rule is not sound because psychiatrists are sometimes asked to render
Objection,
opinions.
hearsay.
He's an expert.
Overruled.
Without conducting an examination of an individual. Examples occur in particular in certain forensic cases and consultative roles. This objection attempts to subsume the rule with its exceptions. What this objection misses, however, is that the rendering of expertise and or an opinion in these contexts is permissible because there is a court authorization for the examination or an opinion without examination. And this work is conducted within an evaluative framework, including parameters for how and where the information may be used or disseminated. You see that?
I do, yes.
And this court authorized Dr. Spiegel to testify in this case, correct?
Yes.
Okay, thank you. I have nothing further.
All right, redirect.
Dr. Shaw, Mr. Nadelhoff just asked you about the court authorization of Mr. Depp's evaluation. Are you aware that the court has twice denied Ms. Heard's request for an evaluation of Mr. Depp?
I heard that yesterday in testimony, yes.
Okay, thank you. Nothing further.
All right. Thank you, sir. You can either have a seat or you can leave. Thank you. Your next witness. All right. Get the TV.
state your name and address for the record.
Jennifer Howell, Los Angeles, California.
And what is your current occupation?
I run the Art of Elysium, CEO of the Art of Elysium.
Let me just go back. Now, you've indicated that Whitney lived with you from January 2015 May 2015 to April 2016. Are you absolutely certain about those dates?
I am certain, yes. She came and went at different periods, but all of her stuff moved out of my house April 2016.
And I'm sorry, did you say you were 100% certain of that? Could you answer my question?
Yes, she did go back to Amber and Johnny's at different points, but she was still living with me during that time.
The question I asked, because you were talking at the same time Ms. Vasquez was giving an objection, was I believe that you said you were 100% certain of those dates. Is that correct?
Same with me.
All right.
Oh, you previously testified that you were the CEO for Art of Elysium. Is that correct?
That is correct.
And are you still currently in that position?
Yes, I am.
And how long have you been the CEO for Art of Elysium?
I am the founder of the organization, so we did our first workshop in August of 1997, filed the legal paperwork in February of 98 to set up a 501c3. So I guess since the beginning of the charity.
Ms. Howell, when did you first meet Amber Heard?
At the Pineapple Express premiere is where I met she and her sister Whitney.
Do you remember approximately what year that was?
I believe it was around 2008. I'm sure that could be pulled. It was the LA premiere. I think there was probably multiple premieres, but it was the Los Angeles premiere of Pineapple Express.
Was Ms. Heard there with Mr. Depp?
No, this was long before. I was a guest of James Franco, and Amber was in the movie. And so I met she and her sister at to be specific, at the after party of the premiere.
Did Ms. Enriquez end up working for Art of Elysium at some point?
Yes, she did.
What year did Ms. Enriquez begin working with Art of Elysium?
I believe it was in 2014. I don't have those documents right in front of me. I believe it was leading into the year Amber was receiving the award.
And what was Ms. Enriquez's position at Art of Elysium?
Art salon manager, director.
Does Ms. Enriquez still work for Art of Elysium?
No.
When did that end?
2015, I believe.
Each time you saw Mr. Depp, did you ever see him doing any illicit, illegal drugs?
Never.
Did you ever see him consuming excessive amounts of alcohol?
Objection. Never.
Did you ever see Mr. Depp appear intoxicated?
No.
Did Ms. Heard ever show you photographs of depicting injuries on her face or body?
No.
Did Ms. Heard ever tell you that Mr. Depp was abusive towards her?
No.
Mr. Depp paying your legal fees, Ms. Howell, for this deposition and the testimony you've provided in the UK action?
He is not.
Who is?
Myself.
Do you feel any particular sense of loyalty towards Mr. Depp?
None at all.
Do you feel any sense of loyalty towards Ms. Heard?
None at all.
Ms. Howell, do you recognize this check as the check that the Art of Elysium received on behalf of Ms. Heard for a donation, an anonymous donation of $250,000?
Yes. Yes.
I believe you testified previously that you understood that the anonymous donor was Elon Musk. Is that true?
Yes.
If I could please have Exhibit 4 brought up. And for the record, it's base stamp JH 22 through 29.
Good for.
Do you recognize this document, Ms. Howell? And if you need to scroll through the 8 pages, feel free.
Can you scroll down? Yeah, I recognize that.
And what is this?
That is an email, I believe, I sent to Whitney.
Scrolling up to the first page of this attachment, who is Marcel?
Paraso?
Sure, Paraso.
He is one of my oldest friends in Los Angeles who has served as a board member of the Art of Elysium and is one of my biggest confidants here in LA, kind of for the course of my career.
I'm going down to the 3rd page of this exhibit. Thank you. This is an email, Ms. Howell, that you sent to Whitney Henriquez on or about Tuesday, July 28th, 2020 at 11:02 a.m.
It is.
This is a true and accurate copy of an email exchange that you sent to Ms. Henriquez?
Yes, I believe I'm the one who gave that. Yes, it is.
And then did you forward this email exchange and the attachments to Marcel Parasal?
Yeah, I asked him to keep it for me.
Why did you send this email and letter to Ms. Henriquez?
Because I've struggled very much with what to do in a situation that I love someone who I know is doing something very wrong, and I know that they're doing it because they're trying to protect their sister, and I'm trying to protect her, and I'm just trying to get her to wake up and do the right thing, which is tell the truth. It's the only thing that can help everybody involved in this case.
Ms. Howell, do you recall submitting a witness statement in the United Kingdom?
Yeah, they basically just called to verify the witness statement that was submitted previously.
And do you recognize this document to be the witness statement and the declaration that you submitted in the UK? And if you want to scroll down to look at it.
Yes, I recognize it.
And at the first page, do you see a date on this document?
January 13th, 2021.
And is this document a true and accurate copy of the declaration that you submitted in the UK proceeding on or about January 13th, 2021?
Yes.
And are all the statements in your UK declaration accurate and true?
I mean, yes, I signed it, yes.
All right, let's pull up what I believe was Depp Exhibit 9. It's been marked as Depp Exhibit 9. Exhibit 9. So, Ms. Howell, earlier you were shown this document. Scrolling to the end of it.
Can you go? Okay.
There. Did Mr. Waldman assist you in drafting this email?
Absolutely not.
Did you speak with Mr. Waldman at all about drafting this email?
About writing an email? No. I did that on my own accord.
Did you speak with Mr. Waldman at all about contacting the ACLU?
I do not recall having a conversation with him about that.
And Ms. Howell, you testified earlier that you received a check from Fidelity Charitable in January of 2018. Is that correct?
I don't know if I said the date, but yes, I received an anonymous donation from that check that was submitted. Whatever it's on there, I just don't know the date off the top of my head.
And you testified that there was a letter sent along with that that said that it was in honor of Amber Heard?
Yes. Richard, I was guaranteed 20 minutes with him after being attacked for 3.5 hours by your side the last time. So I am going to stick by what I was told before entering this and what your side agreed to.
All right, your next witness.
Your Honor, Mr. Depp calls Candy Davidson Goldbraun, who is the corporate designee of the Children's Hospital of Los Angeles.
All right, and that's by deposition, is that correct?
Yes, Your Honor.
Okay.
Goldbraun, is it your understanding that you're here to testify today on behalf of the Children's Hospital?
Correct. Yes.
Okay. So as of June 2018, had any payments been made by Ms. Heard to the Children's Hospital in connection with the $3.5 million pledge, aside from the original $100,000 check from Mr. White in August of 2016?
Yes, there was a payment, a gift on January 9th of 2018.
And what amount is that gift that you're referring to?
$250,000.
Okay, and was that gift made by Ms. Heard or on Ms. Heard's behalf?
By Ms. Heard.
Okay, and what are you basing that statement on?
By the check that we received from Fidelity. Fidelity Charity that came to Children's Hospital Los Angeles.
What is this document?
The letter to Mr. White from myself inquiring about further installments on the pledge that had not been fulfilled.
And why did you write this to Mr. White on June 14th, 2019?
I was trying to figure out if there were any other payments coming from Mr. White to fulfill the pledge, because Children's Hospital Los Angeles had not received any other correspondence from him.
And what is this document?
It is a letter to Ms. Gottlieb from myself on behalf of Children's Hospital Los Angeles, inquiring about additional gifts, pledge payment installments.
This letter appears to be directed to Miss Amber Heard, care of Jody Gottlieb. Is that correct?
Correct.
Who's Jody Gottlieb?
the Children's Hospital Los Angeles record, Jody Gottlieb was our contact for Ms. Amber Heard.
Ms. Goldbraun, why did you send this letter to Ms. Heard and Ms. Gottlieb?
I was trying to see if the pledge was going to be fulfilled or not.
In your experience, is it common practice for anonymous donors when making donations to, in one paragraph, state that they wish to remain anonymous, and in the very next paragraph, identify themselves?
Yes,
That is common?
it is common for donors to want to remain anonymous publicly, but allow the charity to know who they are.
Between June 2018 and the dates on which you sent the letters to Ms. Heard and Mr. White in June of 2019, were any additional funds received from Ms. Heard?
No.
Okay, so as of June 2018, a total of $250,000 had been received as far as the Children's Hospital is concerned from Ms. Heard. And that was the same amount that had been donated a year later in June of 2019. Is that accurate?
Correct.
As of the date of this deposition, March 30th, 2021, how much in total has Ms. Heard donated to the Children's Hospital?
For this particular guest, in her lifetime,
From 2016 to present.
$250,000.
Ms. Goldbrun, you recall we were speaking about this letter a few minutes ago?
Correct.
All right, and this was a letter that you sent to Ms. Heard, correct?
Correct.
Did you ever get a response to this letter?
No.
As of October of 2018, how much money had Ms. Heard directly donated to the Children's Hospital?
$250,000.
As of March 30th.
I'm sorry, I didn't hear the end of that.
Sorry, I just realized. You said October 2018?
Correct.
Okay, yeah. $250,000.
Okay. As of March 30th, 2019, how much money had Ms. Heard directly donated to the Children's Hospital?
$250,000.
What is your understanding of the length of time over which Ms. Heard pledged the gift of $3.5 million to Children's Hospital?
There was no date arrangement with Ms. Heard to have this pledge paid off in a particular time.
If Ms. Heard were to pay this, the rest of the $3.5 million in 2 years or 5 years, would Children's Hospital welcome that?
CHLA welcomes every and any donation that comes its way.
Has Amber Heard's pledge of the $3.5 million to Children's Hospital expired, to your knowledge?
Not that I'm aware of, no. It has not expired.
All right, thank you. Your next witness, or?
Your Honor, I think we've concluded our witnesses for today. We will have more live witnesses tomorrow.
Okay, all right, ladies and gentlemen, that'll be the end of your day for today. Again, do not do any outside research, do not discuss the case with anybody, and we'll see you tomorrow morning at 9 a.m., okay? Thank you. All right, you want to have a seat for just a moment because we do have a few proffers going to be done. Just for the record, we talked about it earlier. I will charge the 30 minutes extra time for today to the plaintiff's team. so we can stay on time.
Understood, Your Honor.
Okay. All right. And I believe, Mr. Rodenborn, you had some proffers you wanted to do for testimony.
We did,
for
Your
the,
Honor,
for the record.
testimony in a few exhibits. Mr. Nadelhoff is actually going to
Okay,
do that.
Mr. Nadelhoff, if you want to proffer testimony for the record as to the testimony that the court has sustained objections.
Here, Your Honor, it's a box here, so I just
All right, that's fine. You can stay there as long as you stay close to the microphone. I
Okay.
appreciate it.
And Your Honor, what I will do is I'll explain what we're proffering the evidence for, and then we have copies.
Good.
Which I'll provide to you. We'll provide them to you electronically, or I don't have another copy for you right now, but we'll provide.
That's
them.
fine. Go ahead. Yes, sir.
Okay. Your Honor, for Laurel Anderson, on March 31st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Laurel Anderson, a clinical psychologist who worked with Ms. Heard and Mr. Depp. Dr. Anderson testified in the therapy session. Ms. Heard reported to her that she was slapped by Mr. Depp, that he hit her in the head, had her hair pulled by Mr. Depp, kicked her in the leg, and that Mr. Depp gave Ms. Heard bruises. Ms. Heard also reported that Mr. Depp was the first to initiate any violence. Ms. Heard also reported that she hid in a bathroom to protect herself from Mr. Depp. Ms. Heard also reported to Dr. Anderson that Mr. Depp threw a phone at her on May 21st, 2016, hit her, and held her hair. Ms. Heard also reported to Dr. Anderson that she was a victim to Mr. Depp's abuse. The testimony is contained in Dr. Anderson's deposition transcript, which is Exhibit A. The court also excluded records of Dr. Anderson from Ms. Heard's and Mr. Depp's therapy sessions and a treatment summary, which are Exhibits B and C. Mr. Depp objected to Dr. Anderson's testimony as described in medical records, stating that they were hearsay and that they did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objection on the grounds that the testimony and exhibits were hearsay. For Dr. Kipper, on March 31st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. David Kipper, Mr. Depp's physician. Dr. Kipper testified Ms. Heard voiced concerns of Mr. Depp's behavior while on drugs and alcohol, that Mr. Depp tried to fight and push Ms. Heard while he was attempting detox on his island, and that she found lots of cocaine in February 2016. Dr. Kipper also testified he told Mr. Depp to, quote, bury the dragon, which referred to the bad feelings that Mr. Depp has inside him. This testimony is contained in Dr. Kipper's deposition transcript, which is Exhibit D. Dr. Kipper also testified about an email he wrote explaining Mr. Depp's detox treatment. In the email, Dr. Kipper wrote to Mr. Depp's sister that Mr. Depp had fundamental issues with anger, romanticized the drug culture, and had no patience if his needs were not met. This email is Exhibit C. Exhibit E. Mr. Depp objected to Dr. Kipper's testimony and the email stating it was hearsay, that it did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objection on the ground that the testimony and exhibits were hearsay. Deborah Lloyd. On March 31st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Debbie Lloyd, Mr. Depp's nurse. Ms. Lloyd testified Ms. Heard voiced concerns about Mr. Depp's behavior while on drugs and alcohol, and that Mr. Depp worked himself up into a rage and was trying to fight Ms. Heard while he was attempting detox on his island. This testimony is contained in Ms. Lloyd's deposition transcript, which is Exhibit F. Also, Ms. Lloyd kept nursing notes on these issues that she testified to, which is Exhibit G. Mr. Depp objected to Ms. Lloyd's testimony and portions of the nursing notes, stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objection on the ground that the testimony and portions of the nursing notes were hearsay. Aaron Borum-Filati. On March 31st and April 1st, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Ms. Filati, Ms. Heard's, and Mr. Depp's nurse. Ms. Filati testified that Ms. Heard reported to her on December 16th, 2015, that Mr. Depp headbutted Ms. Heard in the forehead. This also was contained in Ms. Filati's nursing notes, which is Exhibit H. Ms. Filati further testified that Ms. Heard reported being freaked out after the December 2015 incident and testified to text messages between herself and Ms. Heard, where Ms. Heard reported the incident of abuse. These text messages are Exhibits I, J, K, L, and M. Ms. Filati also testified that on May 21st, 2016, Ms. Heard reported that Mr. Depp became completely delusional and crazed and hit Ms. Heard in the face while she was on the phone with IO Tillett Wright. Ms. Filati testified to text messages reporting this as well, which are contained in Exhibit N. The testimony is contained in Ms. Filati's deposition transcript, which is Exhibit O. Mr. Depp objected to Ms. Filati's testimony, portions of the nursing notes, and the text messages referenced stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on the grounds that the testimony and portions of the nursing notes and the text messages were hearsay. Amy Banks, Dr. Amy Banks. On April 29th, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Amy Banks, a clinical psychologist and relationship consultant who worked with Ms. Heard and Mr. Depp. Dr. Banks testified that in therapy sessions, Ms. Heard reported that Mr. Depp attacked her physically, including by hitting her with his hand. Dr. Banks also testified that Ms. Heard reported that Mr. Depp cut his finger off and burned himself with a cigarette. Dr. Banks also reported that Ms. Heard told her that Mr. Depp initiated the violence while in a session with Mr. Depp, and Mr. Depp did not object to the characterization of the violence. Finally, Dr. Banks testified that she believed Ms. Heard's accounts of the violence and that Ms. Heard was a victim of domestic abuse. This testimony is contained in Dr. Banks' deposition transcript, which is Exhibit P. Mr. Depp objected to Dr. Banks' testimony, stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment and for providing improper expert opinion. The court sustained the objections on the grounds that the testimony about the abuse was hearsay and that Dr. Banks' testimony that Ms. Heard was a victim of domestic abuse was improper expert opinion. Connell Cowan. On April 29th, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Connell Cowan, a clinical psychologist who worked with Ms. Heard. Dr. Cowan testified that in the therapy session, Ms. Heard reported abuse by Mr. Depp, including text messages and medical notes, where Ms. Heard reported in December 2015 that, quote, Johnny did a number on me, end quote. This testimony is contained in Dr. Cowan's deposition transcript, which is Exhibit Q. It is also contained in Dr. Cowan's medical notes in Exhibit R at Dep 9122 through 23 and is contained in text messages that are Exhibits S and T. Mr. Depp objected to Dr. Cowan's testimony, stating it was hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on the ground that the testimony about the abuse was hearsay. Alan Blaustein. On April 29, 2022, the defendant attempted to designate certain portions of the deposition testimony for trial of Dr. Alan Blaustein, a clinical psychologist who worked with Mr. Depp. Dr. Blaustein testified that in the therapy sessions, Mr. Depp reported that he had cut himself as a child and burned himself with cigarettes. Dr. Blaustein also testified about the drugs that Mr. Depp was on, as reported to him by Ms. Lloyd. This testimony is contained in Dr. Blaustein's deposition transcript, which is Exhibit U. This information was also contained in emails, which are Exhibits V, W, and X. Mr. Depp objected to Dr. Blaustein's testimony regarding the cutting and burning himself as speculation, and the testimony regarding the drugs Mr. Depp was taking as hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on these grounds. Bonnie Jacobs. On May 4th, 2022, the defendant attempted to introduce into evidence the treatment notes of Dr. Bonnie Jacobs, a clinical psychologist who worked with Ms. Heard. The treatment notes show Ms. Heard reporting abuse by Mr. Depp, including sexual violence. The treatment notes are Exhibit Y, and based on the court's ruling, the defendant did not call Bonnie Jacobs as a witness. Mr. Depp objected to Dr. Jacobs' notes as hearsay that did not fall into any exceptions, including statements for purposes of medical treatment. The court sustained the objections on those grounds. I have some more. Give me a moment.
As long as you don't just keep turning every page in that book.
No,
I'm not staying for that.
It is not.
Okay.
The UK judgment. On April 29th, 2022, Ms. Heard moved to allow evidence and questioning regarding the UK judgment and for admission of the judgment itself, which is Exhibit Z. In support for her motion, Ms. Hurd argued that Mr. Depp had opened the door to the admission of the judgment by presenting evidence of damages after the date of the judgment on November 2nd, 2020. For example, Ms. Hurd observed that Mr. Depp had sought damages for losing his role in Pirates of the Caribbean 6, a movie that had not yet been made. Ms. Hurd further observed that Mr. Depp testified that the op-ed had caused him and his family irreparable harm, thereby suggesting that his reputational harm had continued to the present. Ms. Hurd noted that Mr. Depp's expert designation indicated Michael Spindler relied on Mr. Depp's earnings from 2019 to 2021 when reaching his opinion, which resulted in an amendment to the designation. Ultimately, the court found that Mr. Depp had not opened the door to the admission of the UK judgment and overruled the motion, which the court did again today with Mr. Banya's opinions. Finally, Adam Bercovici. On May 19th, 2022, Ms. Hurd attempted to call Adam Bercovici, who is an expert in the policing and Los Angeles Police Department policing of domestic violence calls for service. Mr. Bercovici would have testified to his qualifications in the field of policing and LAPD policing of domestic violence calls for service as follows, and further outlined in Ms. Hurd's fourth supplemental and rebuttal disclosures dated March 31st, 2022. Mr. Bercovici spent 30 years with the LAPD, retiring in 2012 at the rank of lieutenant. He has extensive experience as a patrol officer, field supervisor, uniformed watch commander, both as Sergeant 2nd and Lieutenant 1, along with multiple assignments as an officer in charge, Lieutenant 2nd of specialized detective units. During his tenure with the LAPD, Mr. Bercovici held numerous positions directly responding to and overseeing subordinate officers' responses to the domestic violence calls for service, including as a patrol officer, supervisor, watch commander, and assistant watch commander. And actually this, Your Honor, is the person who prepared this prepared a longer brief of what he was going to say. Is it okay to just submit it rather than hearing me read it all?
Any objection to that?
No objection.
No objection. Okay.
Okay.
That's fine.
And with that, that's
Okay.
proper.
You just scared me with the size of that.
No,
book.
I understand.
Okay. All right, that's fine. If you can get Jamie our copy of it, we'll make sure it becomes
course,
part
sir.
of the record as well, okay?
Thank you. Mm-hmm.
All right. Do you have any proffers, Mr. Chu, that you need to, at this point?
Not at this time, Your Honor. Thank you.
All right. Then I think there's just a couple of things I need from you. Like tomorrow, let me, by the end of the day tomorrow, if I could get clean jury instructions without the cites on them for the ones that have been admitted, and also the verdict forms as well, if that's been worked out, okay?
Your Honor, we sent revised jury instructions to them yesterday morning and a revised verdict form today, so just waiting to get
Okay,
back, but
sure.
we'll coordinate.
All right, thank you. And you're working with Jamie about some exhibits. There's some that were, both sides noted that were in evidence that are not, so I want to make sure everybody gets everything cleared up. You're caught up? Okay, good. All right, just keep that going so we can get that, make sure that's taken care of. As far as time left, Sammy, today, I can give you a rough estimate for two reasons. One, you had some depositions, so make sure you give the breakdowns to Sammy about those. And two, Sammy wasn't here today. He had a mandatory CLE that he had to do, so I just did a rough estimate, and I want to qualify that as a rough estimate. But it looks like the plaintiff has used about 5 hours today, and the defendant used about 1 hour and 15 minutes, is what I have, okay? And again, that's a rough estimate, so don't expect them to be the same, but Sammy's going to get to it this evening and send you an email this evening with the actual accurate times, okay? Anything else?
No, thank you, Your Honor. Thank you.
All right.
No, Your Honor.
Okay.
Thank you.
Have a good evening. We'll see you in the morning.
You too. Thank you.
All right.